at when you're trying to look at this question. Now, the other thing which you would probably appreciate, although this is very frequently done, is that in agreements, in contracts, there are often labels that will be put on the particular person. So someone says, I want this person to be a contractor, and so they use that label in the comprehensive written agreement. They label them as a contractor. But what you label a person as is basically irrelevant in the contract. What is relevant is what the terms actually say and, in substance, what's going on there. Now, as you would expect, and if you have ever looked at this point before, the right of control over the individual is one of the key factors. In fact, probably the most important factor. So that is who gets to call the shots in relation to how the work is done. And so if someone is integrated into a business, even though you might call them a contractor, but yet they're taking directions from other people in the business as to how they go about doing their work, then they're going to be dealt with as an employee. Now, remember, it's in the contract itself that we are working this out. What does the contract say about the way the person is directed and how they go about doing their work and so forth? If, on the other hand, the person basically gets to do their work by themselves and they work out how they're going to do that and they run their own show, then they have a right of control over their own work, and that means that the individual is more likely to be treated as a contractor. Now, you've probably all seen this situation before. Someone says, I've got an ABN, I've got an Australian business number, therefore I'm not an employee. And indeed, this concept is out there in the community and amongst also people that engage these sorts of people. Now, let me just talk about that for a minute. So to get an Australian business number, you have to comply with the Australian Business Number Act, and it uses terms that are very similar to the GST law. Now, what it says is that you can't get an ABN unless you are conducting an enterprise. Now, when this first came out in 2000, and I looked and I was very much involved in that back in those days, I wondered whether the courts and the AAT might adopt the view that if the government gave you an ABN, that is the tax office, because they administer it, if the tax office gave you an ABN, are they thereby admitting or proving that you are in effect running an enterprise? Because that's a requirement. You're not supposed to get an ABN unless you are running an enterprise. However, the way it's worked out is that that's not the case. The AAT particularly will look at a situation where a person's got an ABN and they may say, well, they're not conducting an enterprise anyway, they shouldn't have got the ABN, and just because they've got one doesn't mean they're going to be treated as conducting an enterprise. So the thing is, having an ABN doesn't mean a lot when it comes to the question of whether a person is an employee or not. It has some influence, yes, but in many situations where individuals get an ABN, the reason that they've done that is because they've answered the questions on the tax office website in the way that will enable them to get the ABN. And there are ways to answer those questions and ways to not answer those questions that will ensure that you get an ABN. And so getting an ABN is a relatively easy thing to do, but it doesn't mean that you're an employee. Now, one other thing about this that the High Court did say is that if you have your comprehensive written agreement, we won't consider that to be something to look at if, in fact, it is a sham. So a sham basically is where you're setting out something in a contract and everybody knows you're not going to do what that says. It's just a document that has words on it, but everybody knows that they're going to do something else. If it's a sham, then we don't look at this comprehensive written agreement idea. We then start looking at what people have actually done. Now, what is very important, and this goes back to this control question, is whether there is a true unfettered right to delegate. Okay, if you have the true right to delegate your work, if that is the case, then you will be treated as a contractor. And I might say that that will extend into the extended definition of employee under the superannuation guarantee law. So although this topic tonight is not so much on that, but let me just speak about that for a minute. You should be aware that under the Superannuation Guarantee Act, there is a definition of who's an employee, but there's also an extended definition, and that brings into the employee net, if you like, people who are not actually employees, but they are deemed to be so by the law. Now, one of the important things that has been highlighted in recent cases is that if a person has a true right to delegate, then that extended definition will not apply to you. Okay, so the question is, in the contract, remember, we're saying in this comprehensively written contract, is it the case that the individual has the right to delegate the work or not? Now, whether they actually delegate the work is irrelevant. So that's the multifactorial approach, which we don't do anymore. The question is, what does the contract say about whether the person can or cannot delegate the work? But once you've got the delegation, then you're basically home and hosed. You're a contractor if that's what you want. Also, if the contract, this again, we're talking about our comprehensively written contract, if that is a results-based contract, that it is a contract to produce a result. So, for example, a contract to produce a set of software programs that does X, Y, Z. That's what the person is being contracted for. Or perhaps there is even the result of, let's say, cleaning a building. The result is that you've cleaned the building, and so forth. So if it's a contract for a result, then you will be treated as a contractor. But if it's rather a contract for the engagement of a person for a particular period of time, then it won't be a results-based contract. The other thing that's looked at in this is the question of who's taking the risk. Is it the person doing the work? If things go wrong, what happens then? Is the person that's doing the work, are they liable for defects in the work? Do they have insurance? All of those sorts of things are looked at. So the more risk that is applied to the person that's being engaged, then the more likely it is that they're going to be a contractor. There's also the question of goodwill. That is, when the person is doing the work, is there goodwill that is accruing to their business or not? Are they building up a clientele, for example? Are they building up an asset that maybe they could sell? So the question is goodwill accruing to the person when they're doing the work? So the key to all of this is that you look at this comprehensive written contract. Remember, that's at the start. What was the intention of the parties by looking at that contract, and we bring in all of these other things in the contract, not the way it's performed, but in the contract, and ask ourselves, when we look at all of that, then what have we got overall? And if we say by looking at the contract that the person's a contractor, then that's what you've got. Now that is a major change to the way it used to be. And it is, as a broad statement, a favourable thing for people who want to engage contractors. Okay, so that's the background of the tax ruling. And look, it's a good tax ruling. I think when I looked at the ruling in consideration of all of the cases that have come out on this point, I thought it was quite a good summary. It does quite a good job of treating the High Court decisions correctly. I thought the tax office might hedge their bets a little bit with it, but no, I think that that's a pretty fair point. So if you really want to get to grips with this, I would recommend a reading of the tax ruling because it's quite good. We're now going to move on to the practical compliance guideline. Now, the tax office over recent years has tended to produce these practical compliance guidelines, sometimes in conjunction with tax rulings and sometimes not. Now, I have to say that personally, as a tax professional, I'm not a great fan of these practical compliance guidelines. The reason for that is because they become quasi-law. Now, practical compliance guidelines are basically directions to the tax office as to whether they're going to come and chase you or not over a particular point. So this PCG is a companion to the tax ruling, and it's about classifying workers as employees or independent contracts, but it's the tax office's compliance approach. Now, this particular ruling, in my view, is compulsory reading for accountants, particularly in public practice. But if you are in an organisation that engages contractors, this PCG is compulsory reading. You must know what it says. Why? Because it says things that have never, ever been said before by the tax office in relation to the way they perceive the risk of this issue. And whether it's technically right or not, I'll just put that aside for a minute. But the tax office is saying is that there are things you need to do, and there are 7 things, which I'll get to in a moment. And if you want to be in the very low risk category, that is, you want to know that you're not being pursued by the tax office, then you've got to tick those 7 boxes. And some of those boxes have never been said before. And so this is why it's critical that if you've got anything to do with this particular matter, this is something you must know about. So just remember that this is a practical compliance guideline. It's about how the tax office decides whether they're going to come and chase you or not over this issue. Now, practical compliance guidelines are not binding public rulings. So like the tax ruling, that is, it has a status under the Taxation Administration Act. And the tax office says this part of the ruling comes under the Taxation Administration Act as a public ruling. Practical compliance guidelines are not like that at all. They don't have a status. They are simply the tax office saying, this is what we think about whether we come and chase you or not. Now, the way this practical compliance guideline is set out is that it looks at 2 different ways that the tax office might come and investigate you or your client or your business. And number 1 is the proactive case selection. So basically that means your number has come up in the tax office. There's something in the algorithms or the reporting processes of the tax office that says, this business ought to be investigated. Proactive case selection. The other thing, which is also happening quite a lot, is that people are going to the tax office and saying, I worked for this organisation and I didn't get superannuation contributions paid on my behalf. And we all know that that happens. And so that's what's called an unpaid superannuation query. And so the tax office divides their approach into these two ideas of being investigated. Now, just I mentioned about the unpaid superannuation query. The tax office gets a lot of these, a lot of them. And indeed, in recent times, they have said that they can't cope with the number of superannuation queries they're getting. So just be aware of that. Now, it is not my general policy to give you slides, to present slides that have got lots and lots of words on them. However, on this particular occasion, unless I do that, I can't explain what this PCG is about. So unfortunately, I've got to give you a whole bunch of words. Otherwise, I won't go through all of the words, but this will give you the understanding of the way this PCG works. So what I'm going to do is talk about two tables that are in that PCG. One is called Table 3. Don't worry about Table 1 and 2. And another one is Table 4, which I'll get to in a moment. Now, Table 3, its idea is to tell you whether the tax office is going to come and chase you or not. So you will see that it's split up into risk zones, and it's split between the unpaid superannuation query and the proactive case selection. So that's those two modes. And it then says, well, depending on risk you're in, now the risk zone is determined by the next table that I'm going to look at. Okay, so just to explain that, you're actually supposed to go to Table 4 first of all, and then come back to Table 3. But I'll get to Table 4 in a minute. So, for example, if you decide you are in the very low risk zone, then according to that, no matter whether you're unpaid superannuation query or proactive case selection, the tax office will not come and chase you. No further compliance resources will be applied. They will not investigate you if you are rated in this very low area. Now, the only difference in the whole of this table is the bit that I've got starred here. So if we have an unpaid superannuation query, that is, someone's gone to the tax office and said, hey, I haven't had my superannuation contributions paid, then the tax office will, if you're in the low risk zone, compliance resources will be applied to test whether the worker meets the extended definition of employee under the Superannuation Guarantee Administration Act. Now, that was what I was referring to before. This is subsection 3 of section 12 of the SGAA, and it brings into the definition of employee those people who are not employees, but they are dragged in by the definition of the law. And one of those things is where a contract is wholly or principally for the labour of a person. Okay, if a contract is wholly or principally for the labour of a person, then you are dragged into the definition of an employee. However, I might just add that if you have the right to delegate, then that provision doesn't apply. So in this table, that is in fact the only difference that we're talking about, because whether we're medium risk or high risk, it's the same idea. So let's look at if you're in the medium risk, for example, let's say we're a proactive case selection, then it says compliance resources will be applied to test whether the worker is an employee under the ordinary meaning or meets, that is of an employee, or meets the extended definition of employee under the SGAA or both. Medium risk arrangements will be given lower priority than arrangements that are rated higher risk, whatever that means. And then high risk says, we're definitely coming after you. So medium and high means you're going to be investigated. This one here says, just if you're low risk, then we'll look at this particular part of it. Okay, so that's table 3. Now, the real substance of this comes in the next table, table 4. Now, this table has 7 criterion, and it goes over 3 slides. So what I'm going to do is begin to just orientate you to this table. Now, the idea of this is that you look at your criterion and you work out what risk profile you have. And so you work that out, and then you go back to the last table and you say, here I am, I'm a low risk and I'm a proactive case selection. So therefore, no further compliance resources will be applied. So that's the way it works. So let's come back here, and that's what we're doing. We're trying to work out which category are we in. Now, one of the curious things about this table, and I have to say I find it a bit curious, because you can look at it and there isn't actually a lot of difference between a lot of the columns. So let's start off with the first criterion. There is evidence that both parties, so that's the worker and the person that's engaging them, intended for the worker to be classified in the same way, either as an employee or as an independent contractor. So notice evidence. Now, basically that means you've got something somewhere in writing, which might be the contract, but number 2 is the contract that we'll talk about in a minute. So they want file notes or letters or emails or something like that that demonstrates both parties understood that they were either to be a contractor or an employee. And so if you've got that, then you're in the very low category, at least for that criterion. But notice the low and the medium are exactly the same. But the high is anything that's not medium, low, or very low. So in essence, we don't really have 4 categories. What we've got is a very low and a high. And the whole of the table kind of operates in that way. And it's a little bit curious the way the table's set out. But at any rate, this is what we've got. The key thing is that these 7 criteria need to be looked at. And if you're a business or you've got clients you're advising, they want to be in the very low category. In other words, you're saying to your client, for example, in relation to this employee contractor point, do you want to have a situation where the tax office never comes and investigates you? Is that what you would like? And many clients will say that, yes, and many businesses will say that. Then, if that's the case, you need to tick all of the 7 criteria and say, yes, I've done all of those things. And if that's the case, then you can confidently say you're in the very low category. Let's go on with the other criterion. There is a comprehensive written agreement. Now, we spoke about that before. That governs the entire relationship between the parties. So there the tax office has picked up the words of the High Court and said, you've got to have one of those. Now, note, the tax office thinks that that could be something different to criterion 1, which is, again, a little curious, because if it's a comprehensive written agreement, why doesn't it also cover criterion 1? But at any rate, they see a difference in it. Number 3, there is evidence to show, again, the word evidence, to show that both parties understood what the workers' classification meant and what the tax and superannuation consequences of what the classification would be. Now, you might think, wait a minute, isn't that the same as what number 1 is? And wouldn't that have been covered in number 2? Well, the answer is no, because the tax office see a difference in this. Notice the word meant. So there's evidence that both of them understood that what was going to flow from a person being either an employee or a contractor. And there must be evidence that that has been the case. Now, evidently, the comprehensive written agreement isn't enough to do that. Otherwise, why have a 3rd criterion? Okay, so there we go. Now let's move on to the next page, which has got criterion 4, 5, and 6. 4, the performance of the arrangement has not significantly deviated from the contractual rights and obligation agreed to by the parties. Now, again, this is harking back to the court decisions, and we mentioned this before. So if it has been the case that the arrangements have significantly deviated from what the contract said, then the question is, what they put in the contract, was that actually what they meant? Is it actually a true contract? Number 5, the party relying on this guideline, the PCG, is meeting the correct tax and superannuation obligations that arise for their intended classification and reporting appropriately. In other words, they're paying all their tax, they're doing all their correct reporting, they're ticking all the boxes as far as the tax office goes, okay? Number 6, now this is where this one and particularly the next one are something that you really need to take notice of. The party relying on this guideline, and that's the engager of the services, obtained specific advice confirming the classification was correct. Okay, specific advice confirming that the classification, employer or contractor, was correct. Now that has never been said before by the tax office. And if you want to be in the very low category, then that is something that you must have. Now, your question might be, who can I get that advice from? Well, there are 3 places: from a lawyer, from a registered tax agent, and from the tax office itself. Now, just on the point with a registered tax agent, a registered tax agent who's not a lawyer is prohibited by law from advising on employment law matters. However, when the matter relates to an act of parliament for which the Commissioner of Taxation has the general administration, and that includes the Taxation Administration Act, then you as a tax agent are permitted to advise on this point. And the last point is in criteria 7, an engaging business relying on this guideline also obtained, so this is in addition to 6, also obtained specific advice confirming the application of the extended meaning of employee under the Superannuation Guarantee Act and communicated this outcome to the worker. Now, I deal with accountants in public practice a lot. And for those of you who are in public practice listening to this, you will realise that this criteria 7 is something that doesn't happen very much at all. That is, that someone's gone out and got specific advice about whether the extended definition under subsection 3 of section 12 of the SGAA applies. But if you want to be in the very low risk, then you have to have it. Now, just note here in the curiosity of this table that if you don't do that, then there's no such thing as low or medium. So it's either high or you're very low, one thing or the other. If you haven't got this, then you are high risk under that criteria. And the table works like that often. Either you're the very low or you're high. And although we've got these 4 columns, in a practical sense, what I would say to you is if you don't tick the 7 criteria and say, I did all of those things, then you probably can't say that you're very low risk, and you are probably, and I say probably, in the high risk zone. And now I know it's not quite like that, but in a practical sense, if you're advising a client or you're thinking about your own business, if you want to be in that very low risk, you have to tick all 7 boxes. Now, what I'm saying is that in the community, particularly in these situations where individuals are being engaged at contractors, you will all appreciate that those 7 boxes don't get ticked very often. Now, this is the big difference with this PCG, and it is very important that you understand it if you are advising your client on it. Let me give you a couple of examples. So here's a company, Aussie Building Cleaners, and they employ people as employees, and they also have independent contractors, and that's quite okay. You can have that. But Maria works as an independent contractor, and then she finishes her engagement with Aussie Building Cleaners, and someone says to her, you should have been paid super, don't you think? Maybe I should have. So off she goes to the tax office and says, hey, tax office, I think I should have been paid super. Now, the question is, what risk zone is Aussie Building Cleaners in? Well, according to this particular example, what happened was at the time of her engagement, Maria chose to be an independent contractor. That is, there's that evidence, remember, evidence that both parties understood what she was supposed to be. Secondly, there was a written comprehensive contract. Thirdly, there were email exchanges that indicated that both parties understood the tax and super implications. So they understood what it meant. There was no significant deviation from the contract. ABC also obtained a private ruling from the tax office on the situation, and presumably that included the extended definition of the superannuation law, and ABC complied with all of its requirements. It paid the taxes and lodged the forms and so on. And so the tax office says, this is the case, even though this is a unpaid superannuation query, this is a very low risk situation and we are not going to investigate it. So that's a simple example. Now this one here is an example of what confuses me about this table. And this is from the PCG. So here we have Frank, and he was engaged by CCC Proprietary Limited, and his engagement comes to an end and his super's not being paid. So he complains to the tax office. So super's not being paid, but it is the case that there's a minute of a meeting with Frank, with the CCC, that said that Frank's going to be an independent contractor, and he understood that that was going to be the case. CCC took advice on the independent contractor classification. There was a written comprehensive agreement, but no advice was taken on whether Frank came within the extended definition of an employee. Now, remember, if you don't do that, in that criterion, you're in high risk. Now, what the tax office says about this arrangement is it's all low risk. And what I don't understand is exactly how they came to that view. So when we look at the 7 criterion in that prior table, the question is, how do we use that? Is it kind of a weighted average before with the 7 criterion? Do we say, oh, we've got 2 high risk and we've got 7 very low risk, so therefore on balance we're a low risk? Is that what you do? And that's not explained in the PCG. It's not explained as to how they came to this view. Because when I look at criteria 3 and criteria 7, there's a view that this company is in the high risk zone. So how is it that they concluded that it was low risk? And it's not explained. And this is one of the curiosities of the way this table works. And I don't think it's really all that functional, the table. But the overall point is this, is that if you want to be in the very low risk zone, make sure you tick all the boxes. Now, here's another example which I'll give. So here we have Sasha, and she was engaged as an independent contractor doing safety audits at a particular place. And so she's doing that for a while. And so everything's okay. We've got an independent, we've got the agreement, and, you know, we've ticked all our 7 criteria. However, after a time, the company that's getting her to do the work says, look, why don't you become an employee now? Why don't you have a permanent engagement? In other words, you can work here all the time if you like and doing your safety audit thing, but you're still a contractor. Then the tax office says that that's a high risk situation because when the situation changed, the documents didn't change. So originally there was something there, but when her arrangements changed, such as she was working there all the time, then the documents didn't change. So therefore that puts her in the company in the high risk area. So here is my summary of what we have here. So first of all, the tax ruling is a good summary. And if you want to really get to grips with the sort of technicalities of this, then have a read of it, because it is a good summary and a good explanation of it. But the main focus for you in practice, whether you're in public practice or you're representing a company, your main issue is going to be with that PCG. The question is, do you want to be in the very low risk area or not? The two-table approach, in my view, is a bit complicated and it's a bit confusing and it's a bit hard to understand. But again, yeah, so that's the comment. How Table 4 is supposed to interact with Table 3 is not at all clear and is not explained. And so the kind of the closing comment I make is this, is that it seems almost mandatory for those engaging individuals that are intended to be treated as contractors to obtain specific legal advice on the individual's classification as an employee or contractor, and to also obtain advice concerning whether the individual comes within the definition, extended definition of employee in the SGAA. To not do so has the risk of landing the engager of the individual in the high risk zone. And I think that that is if you take anything away from this whole presentation, that is the key point. And for those of you who are in public practice, where this issue is likely to come up on a regular basis, you should have that PCG at hand. And indeed, if you have clients that are in this industry where they are engaging individuals and treating them as contractor, this is a must advise your client about it. You must say to your client, the tax office has a new approach on this, and if you want to be in the very low risk zone, then you've got to tick these 7 boxes, and that's just the way it is. So that brings me to the end of my presentation, and if I can just give you a little bit of encouragement, you can become a member of my website. And so if you enjoyed the particular style of presentation, you can do that, and you go to johnjeffreystax.com.au. It's a membership that costs $25 a month plus GST. There's webinars basically every week, and you get other resources. There's a newsletter that you can send to your clients and a bunch of other resources to help you in your practice. So there we are. Thank you very much for inviting me today to speak on this topic, because it is a very prevalent topic in the course of the Australian business community. So thanks.
All right. So there's one question on the chat box from
Yes.
Gulshan. Is this possible that a contractor is an employee just for SGAA only, not for PAYG withholding?
Yes, that is correct. Yes, that's a good question. So remember that this extended definition under the superannuation law is for people who are not by definition employees. But because of the superannuation extension in subsection 3, it ropes in certain people and will deem them to be employees even though they are not. And so the key one to think about is the question of whether the person has been engaged wholly or principally for their labour. Now, they may not be employees under the ordinary definition, but if they are engaged wholly or principally for their labour and they don't have the right of delegation, then it's almost certain that you've got to make superannuation contributions on their behalf, and this catches people out. It's something that not even a lot of accountants are aware of. And so, you know, the general business community, particularly the small business community, is just blissfully unaware of this particular provision.
Okay. Anyone have any question? You can post on the chat box, or if you happy to unmute yourself and ask a question directly, you can do so. Lina, I think you want to ask a question directly. No, doesn't look like it.
Hello?
Yes.
Okay, so
Hello?
Thomas, you want to ask a question?
Yeah. Thanks. I just have a quick question. Um, with this PCG or the definition between employees, contractors, what will be the interaction between that in the context of superannuation guarantee, PAYG, and works compensation and payroll tax? Are these all like the definition or the kind of like the thought process of determining are the same in all these contexts?
Unfortunately, no. Although they're kind of down the same street, but unfortunately, you have to go to each piece of law. Payroll tax, of course, being a state-based law, and also workers' compensation, and superannuation guarantee is a federal piece of law. And of course, then you've got the tax law to do with whether you're employee. Unfortunately, they're not the same. However, they are down the same street, if I can put it that way. So, and unfortunately, that's probably about the best that I can say to you. And it depends on the state that you're in and the particular approach. Now, particularly with payroll tax, that can rope in people that provide their services through entities. Now, what I've spoken about today is not that. This is only human beings providing their services in their own name. So all of this today was only to do with that topic. Now, when
Like the
you
sole trader ABN, that's what you're
yes,
referring to.
yes, that's that kind of idea. You know, the tradie that turns up to the building site with his ABN. Now that might be okay, but you know, if the tradie is there working for one company all of the time, yes, he's got his ABN. But is it in fact the case, based on their comprehensive written agreement, that that person can be treated as a contractor? Now, it is possible to do it, but you've got to make sure that the terms of the contract are written in that way. And basically, one of the requirements you must have in the tradie example, for example, is that they've got the right to delegate the work to somebody else. But look, your question is a very important question, but unfortunately, it's just too hard to answer, given all of the different pieces of legislation and the different states' approaches to it. But it's certainly, it's down that same street. As soon as you've got a person who you're not treating as an employee, but they look and smell like one, then you need to be thinking about the point.
So is it this ATO PCG is always kind of like, from a practical point of view, is that like a good starting point, even for payroll tax and works compensation purposes?
Well,
Would you
yes,
say that's
you
the
could
good
take that
starting point?
approach. I mean, if you did all of the things that were in that 7 criterion, that would help you a great deal, particularly in the way that the contract is drafted. So that, as I said before, the contract's king. And if that's drafted in the right way, then that may help you with your position with payroll tax and other things. But it's not really correct to say that following the PCG will get you out of the issue to do with the state-based taxes. Yes, unfortunately, that's not very satisfactory, but it's just the way it is.
Okay. All right. Thanks.
Okay, so we got one more from Nidia.
Mhm.
So is it safer for a small company to pay superannuation to contractors?
Yes, you could take that approach. Yes, you know, if you don't mind the extra cost involved, so you could do that. Yes, if you cover off on that point. Um, uh, if you're doing that, of course, you may increase your payroll tax issues as well. It just depends. But what is the safest thing to do if you can do it? And I appreciate that this is the big if. is if the person can provide their services through an entity. Then from the point of view of the federal tax legislation, you're safe, because it is not an employee, is not a human being that is providing the services. However, I admit that that's a practical thing, because, you know, most tradies are not going to be bothered getting their own company and so forth. But if you do pay the super, yes, of course, that helps a great deal. So in other words, you can have a contractor, a person who really is a contractor, and treat them like an employee if you want to. And the tax office is very happy with that.
Okay, I think that's all. That's all the question we have for today.
Okay.
So on behalf of CP Australia City Taxation Discussion Group, Henry, I would like to thank you, John, for your time, effort, and your contribution to our group tonight. If any one of you have any further question, you can contact John directly. I'm sure he'll be able to help you and your client further. And also, please, if you want to become a member of his website, the website's on the screen at the moment. Please join and be part of his website. So thank you all for attending tonight's session, and we hope to see you all back again in 2 weeks' time at CPA office. And until then, please stay healthy and stay connected. Thanks, everyone. Thanks, John.
Thanks, Teddy. And thanks very much for listening, folks.